Yes, Mr. Firth.
My lords, thank you very much. If I may begin by making three general points in relation to this appeal. The first is to note, as I'm sure this court has already appreciated, that you're considering the decision of a specialist tribunal, the Land Tribunal, and a decision from two highly qualified chartered surveyors, FRICS and MRICS, respectively. In the ordinary course, a large amount of deference is due to a tribunal that's heard all the evidence, and that is particularly so where it is a specialist tribunal in an area outside the experience and expertise of most lawyers, i.e. land valuation. The second point is another, I hope, obvious point, but the Upper Tribunal heard all the evidence and read all the submissions. So we had multiple reports from the experts being shown snapshots, tiny snapshots of parts of them, and my legal friend says in some way support his case, but you haven't been shown the whole of them, you haven't been invited to read the whole of them. Those reports had a number of accompanying documents and exhibits that also require consideration, and we had a full day of cross-examination of the two experts. It is manifestly not possible to replicate that within the course of this hearing, nor would it be right to try and replicate it. The third point is the scope of this appeal, which is an appeal on a point of law only. A challenge the evaluative conclusions of a tribunal dealing with a valuation issue is only open to challenge on the very tough Edwards and Bairstow grounds. And if I could just quickly show you in the authorities bundle, tab 8, it's a Court of Appeal decision called Richland Properties, but just to confirm that point, tab 8, page 160, please.
156.
160.
160, yeah.
Paragraph 21. It's actually just the last few lines. Mr. Barnes accepted that this was the sole basis, i.e. there was an error in relation to admitting evidence, on which the tribunal's decision could be challenged, while the appellant disagreed with the tribunal's residual valuation of 4.5 million. That disagreement turned not on any alleged error of law, but upon matters of fact and valuation judgment, which were for the tribunal, not for this court to determine. And it is with that in mind that Lady Justice Aspling gave limited permission. I'm sure, my lords, you've had an opportunity to look at the limited permission, but it is really only in relation to the nature of the asset to be valued. And grounds were rejected insofar as they strayed beyond that. You can find that behind tab 4 in the core bundle, page 37. Those are the preliminary points.
But there is a bit of a problem here, isn't there? Because both the experts and the tribunal followed the RICS guidance, whether it was GN1 or BPGA4. And in order to decide what it was they valued, we've got to look at that guidance, haven't we?
That was going to be my next point, and yes, we do need to look at that guidance, because my learned friend actually hasn't shown you the critical part of the guidance.
Yeah.
The bit that actually tells you how to value a leasehold interest. Right. That's the bit I'm going to show you now.
Right.
So if we could...
So it's common ground that we have to look at the guidance.
It's common ground that the guidance is yes, it's common ground that the guidance applies and should be followed in this case. My submission is that it was a matter for the evaluative judgment of the tribunal, having heard the expert evidence, to decide what that guidance, what the result of that guidance was in this particular case.
Yeah.
And that falls within the Ridgway principle that it's not for this court to re-examine on the basis of a limited consideration of limited materials. The only real error of law that my learned friend purports to identify in my submission is when he says, well, there's no such asset as transferable goodwill. I'll deal with that in due course. But in terms of the guidance and how it applies and what it means, that was for the Upper Tribunal specialist loan trader. But if I may show you that guidance, because although I make this point in my skeleton argument, I deal with it in the alternative on the assumption that maybe my learned friend has got a broader permission than I've understood. I deal directly with his points because there's good answers to everything my learned friend is saying. I wouldn't want to leave this court with any other impression. The version of the guidance I've been working from is at the end of the authorities button. It's a slightly clearer copy, but I appreciate my learned friend's been using the supplemental button. So that's tab 8 of the supplemental.
Yeah. Well, I think I'm going to have it in the supplemental bundle, but it's the same, isn't it?
It's the same. So if we could just look, please, at the structure of this guidance. Section 1, background. Section 2, terms used in this guidance. And then you've seen the various definitions my learned friend referred you to. But what he didn't take you to was section 3, the profits method of valuation. I'm going to come back to that in a moment. 4, valuation special assumptions. 5, valuation approach for a fully equipped operational entity. This might help with some of the questions that my learned friend was facing this morning, but just to note that 5.1 says the valuation of a trade-related property as a fully equipped operational entity necessarily assumes that the transaction will either be the letting or sale of the property together with the trade inventory, licenses, etc. required to continue trading. You're assuming the sale, the purchase of, or the letting of an operational entity. That's the assumption made in this guidance. Then you've got section 6, assessing the trading potential, and 7, valuation approach for non-trading property. So you can see that the critical paragraph, or section, is section 3. And 3.1 tells you the profits method of valuation involves the following steps. Step 1, assess the FMT. Step 2, where appropriate, an assessment is made of the potential gross profit resulting from the FMT. Step 3, an assessment is made of the FMOP, the fair maintainable operating profit. And then step 4. Now it was agreed and decided that step 4A relates to the freehold, doesn't relate to the leasehold. And that says to assess the market value of the property, the FMOP is capitalized at an appropriate rate of return reflecting the risk and reward of the property and its trading potential. Evidence of relevant comparable market transactions should be analysed and applied. B says in assessing market value, the valuer may decide that an incoming new operator would be expected to improve trading potential. And then C, to assess the market rent for a new letting, the rent payable on a rent review, or the reasonableness of the actual rent passing, particularly when preparing an investment valuation, an allowance should be made from the FMOP to reflect the return on the tenant's capital invested, for example, the cost of trade inventory, stock, working capital. The resultant sum is referred to as the divisible balance. This is apportioned between the landlord and the tenant, having regard to the respective risks and rewards, with the landlord's proportion representing the annual rent. The interpretation of the guidance adopted by the tribunal, in accordance with what the experts said, and I'll show you some more of that in a moment, was that step 4A relates to the freehold, but we're not dealing with the freehold. Step C relates to the valuation of a leasehold, and it understands that solely in terms of the market rent. And here we have agreed, it's been agreed that the lease was at a market rent. Nowhere in this guidance does it say or suggest that in addition to the market rent, the landlord gets a premium for the property.
Well, there are 2 points I'd like to ask you about that, if I may. The first is that if you are trying to value a lease, if you're trying to assess the capital value of a leasehold interest, an actual leasehold interest, which is let at a rent which is lower than the market rent, you would have to apply, would you not, some sort of adapted version of step 4A. I mean, suppose that one of these companies is renting a care home for £1,000 a year instead of 225, whatever it is, goes to a valuer and says, what can we get for this if we put it on the market? The valuer would not simply go to 4C, would he? The valuer would somehow adapt 4A, which is what the experts did by deducting the actual rent from the FMOP.
Well, that's the purpose of this guidance is to establish the market value of a lease or of the trade-related property. If you've got something that's being sold for a price less than market value, and you want to undertake a different calculation to work out the difference between what the market value would have been and what's actually paid, then, well, in that case, you would take the difference between the market rent and the actual rent, and you would capitalise it.
So you'd modify step 4C, you say, rather than step 4A.
Well, you're doing something outside the scope of the guidance. You're going beyond that. So the guidance gets you to saying what the market value or the market rent is. If you've got something else and you're saying, well, I need to compare these and find out what the difference in value is, then you're already doing something outside the guidance, because step 4A, as was agreed, as was decided by the Upper Tribunal, relates to the freehold. And that must be right because FMOP is before deduction of any rent.
So is this the proposition that if you are assessing the capital value of a leasehold, you do so outside the guidance?
If you've got a lease at less than the market rent, and you want to know what the capital value of that difference is, then yes, you're not relying on any particular step here. And that was agreed and as found by the Upper Tribunal.
Yeah. The second point about 4C is that it is looking at what the landlord might expect to receive from the tenant. But if we are trying to assess the capital value of the lease, we are not assuming, or certainly not necessarily assuming, that the landlord is going to get anything out of this transaction. It will be a transaction between the lessee and another, likely to be an assignee of the lease.
Yes.
So why does the proposition that the landlord is not getting anything bear on the value which the tenant could get on a sale of the leasehold in the open market?
I'm not sure I quite understood the question, my lord. If the lease is at a market rent, then the market value of that lease, as a bare property interest, will be nil.
Well, you say that, but that's certainly an assertion. That's certainly what the UT decided. But why?
Well, 2 points there, if I may. The first is, in terms of this divisible balance between the land interest represented in our case by a landlord and the tenant who carries on the business, that is exactly what happens in 4C. You have this division of the profit between the two to reflect the respective risks and rewards. A further step, as suggested by my learned friend, of saying, well, we're going to do another division. We're going to take the tenant share and we're going to do another division of that, is not provided for in here. It's contrary to it and begs the question of what interest are we taking into account at the second stage that we left out of account at the first stage. If you read the last words, it says the resultant sum is referred to as the divisible balance. This is a portion between the landlord and the tenant having regard to the respective risks and rewards. So what risks and rewards or interests are left out of account there that is then legitimate to carry out a further division exercise out of the tenant's proportion.
Yeah.
The second point, if I may make in response, is to refer your lordship to the definition of market rent at 2.6. The market rent is by definition what you need to pay to get that land interest. If HMRC is saying, well, no, it's not enough to pay the market rent, you must pay the market rent plus a premium, then it can't be the market rent because it can't be enough to secure the land interest. And if instead they say, well, no, you've got to, you work out what your rent is, say in this case it's 35% of the FMOP, and then you take the 65% and you carry out some further division exercise, and then you capitalize that to its net present value and hand that over. So then you've got the premium plus the rent. But why couldn't you just alter those components in any way? You could have a rent of 50% and a smaller premium, or you could have no rent and entirely a premium, or you could have 100% rent. There must be a situation in which the answer to the question of what you need to pay to get that land interest is solely stated in terms of a rent, an annual rent. And that, in my submission, is what the market rent is. There is a fundamental contradiction, if I may respectfully say so, between saying X is the market rent, i.e. the rent one would have to pay to acquire land interest, and arguing that nevertheless a purchaser would have to pay an additional amount to acquire that land interest. This is exactly the thought process that the Upper Tribunal went through. And you can see that at paragraphs 108 to 111 of the Upper Tribunal decision. If I may refer you there now, it's tab 8 in the core bundle. It's page 103 in the core bundle. And paragraph 108. Because my learned friend showed you excerpts from the Upper Tribunal, but didn't take it as it was written in a flow. 107, you see, the experts were in broad agreement that step 4A applied to the valuation of freehold interest, and step 4C applied to leasehold interests. Step 4C is concerned with assessing market rent. You make an allowance and you get a divisible balance. You then apportion that in regard to respective risks and rewards. 109, the market rent is determined in this case by taking a percentage of the FMOP, and as such it reflects the trading potential of the property. One would expect the tenant's proportion of the FMOP to represent the amount it would require from the business to induce it to take a lease of the market rent and make sufficient return on its risks and for the profit, interest on capital having already been allowed for. And yet the tenant in this case has paid a premium in addition to the rent. What was it for? In our judgment, the agreed market rent must fully reflect the trading potential available to the tenant under the terms of the lease. If that were not the case, as the appellants argue, it would not be the market rent but something less. The premium reflects the fact that tenants are leasing a fully equipped operational entity. From a business point of view, is accepting a lower risk than having to start from scratch. This is a business advantage, which the tenant will be prepared to pay over and above the market rent. So those are essentially the steps that I've just taken this course through, but they're exactly the steps that you find in the profits method evaluation in the guidance. I mean, it was striking this morning that my learner friend did not once take you to part 3 or section 3 of the guidance and explain what his interpretation is. One infers it's quite a difficult point for him. I submit it is. And all the tribunal done, all the upper tribunal lands chambers done, is apply that guidance in accordance with its terms. It has started with the turnover, reached an F mark, which was agreed, and then said, well, that's been provided, and it's agreed that this represents the market rent, and that's the end of the exercise. If there was something less than the market rent, then you might be able to get a premium. But the market rent is the division based on the risks and rewards. And it would be striking, indeed inexplicable, if I may put it that way, if, in relation to a trade-related property, where you have a lease, you get the market rent plus a premium, and the guidance doesn't tell you that, doesn't refer to it, doesn't tell you that, doesn't tell you how to calculate the premium.
You do get a premium because the experts agreed that you do. But your point, I think, is, well, it can't be for the leasehold interest because that's the market rent.
Yes.
Therefore, it must be for something else.
Yes.
And it may not matter what you call it, that's something else, whether you call it business advantage, transferable goodwill, or business goodwill.
Yes.
Whatever it is, it's not the leasehold interest.
Exactly. And the Royal Institute of Chartered Surveyors are only telling you how to value the land interest, the property interest. And that's why they stop at the market rent. That's why they stop there. And in my submission, it would be inexplicable if there was a premium that was the land interest, even in respect of a market rent lease, that this guidance would not tell you that, and would not tell you how to calculate it. And we'll see, as I've set out my skeleton argument in any event, that HMRC's own witness accepted that, according to this guidance, the market value of these leases is nil. And as my lord said, the question that was referred to the Lands Chamber was a question of land valuation. Once the tribunal has gone through the guidance it identifies as relevant and reached a conclusion that, well, this isn't market rent and that means it's nil, it didn't need to go on and say, but here's our opinion on what it actually is for. In fact, we might say that was outside the scope of what is referred to. And so my learned friend is in error in trying to attack that part first, without being able to find any error in the first part, the actual application of the guidance. Because we didn't hear any submissions on section 3, we haven't had any submission as to what error, if any, the tribunal made in applying the guidance according to its own terms. Because there isn't any. There's no error. If I can now show you a few passages from the cross-examination of Ms. Rodriguez.
Just before we go to the details, I just want to be clear about this. Are you saying that in arriving at the premiums, the agreed premiums, the experts and the tribunal were applying the guidance, or are you saying that in arriving at those premiums, they were going outside the guidance?
Well, let's, if I may be clear, the Upper Tribunal didn't say the premium fell within the guidance. And it was accepting my submissions in relation to that. We'll see in a moment that Ms. Rodriguez accepted the premium is not provided for in the guidance, and according to the guidance, the market value is nil. So yes, the premium element in relation to a market rent leasehold is outside the guidance.
Right.
Now it's the application of a similar method as my Lord Justice Snowden said this morning. It's how you value a business. You value a business in a very similar way by applying a multiple to profit or turnover, or depending on what type of business you're applying. So, and this is one of the submissions I made to the Upper Tribunal, which is that depending on how you apply the profits method of valuation, you can either end up with a value for the land, interest alone, a value for the business alone, or a composite value for both of them. So, because in each case you're looking at the profits in some sense and capitalizing them in some sense. But what's clear in this case is that in relation to a leasehold, the guidance says that what you pay for the leasehold is the market rent. That's what you need to pay to get the lease. And it tells you how to calculate that by arriving at the FMOP and then dividing it up. So insofar as there was a premium in this case, it would be outside the guidance. And that's exactly what the Upper Tribunal was concluding. As I said at the beginning, it's impossible to replicate in this hearing what happened below. But nevertheless, I want to give you a flavour, if I may, of the sorts of issues that were touched on in cross-examination, just so you're aware of the detail of the issues that arose and how they came out. So if I may show you a few passages from my cross-examination with Mr. Rodriguez. It's tab 9 in the supplemental. Page 57 of the transcript, if we could begin there, please, which is page 270. The questions I began with were about market rent, and you can see the first question on page 270. So, is the amount that a prospective tenant would have to pay to get that leasehold, is it not? Yes. So that's the point I just made by reference to the definition. We could go to page 59, please. And it's the first question on that page. So question. So this is the part of the guidance that tells us how to apply the profits method of valuation. Nowhere does it say the landlord gets a premium as well, does it? No, it does not. Page 62, please. And it's again the first question on that page. Question. By definition, that property, the particular property, with all the physical features of that property, the market rent is X. I, as a tenant, do not have to pay any more than X to acquire that interest. Is that in that property? Do I? If it was a care home, yes, that was not trading. It was vacant care home. And you wanted to acquire that care home, yes, you would just pay the market rent. So you are saying, for an occupied care home, the market rent is not enough to acquire an interest in that property. No, because there is an additional asset value being generated by use, established use. So this difference in value between a vacant property and an occupied care home is the established use. It's the existing business, which, as you saw this morning in the Muller case, that's exactly what goodwill is. It's the benefit of an established business. Could we then go, please, to page 66? We see, I think, a similar point. 2/3 of the way down, there's an answer. as I explained,
Yeah.
there could be a premium if there is likely to be a premium when the operational entity is maturely trading. So when I was talking about a non-operational entity, maybe I was probably incorrect, and I should have said an operational entity in its infancy, as against mature trading. Yes, you are right, it does reflect chattels. It reflects more than chattels, does it not? It reflects, as you say, established trading history. Yes, which is the goodwill, is it not? No. Why is it not the goodwill? Established trading history is something to be reflected in the trading potential. The definition of trading potential specifically includes trading history. So it's part of the trading potential of the property.
When it says, when the question was, which is the goodwill?
Yes.
What were you intending to distinguish between any types of goodwill?
I'll make submissions later on types of goodwill. In my submission, there's only really two types. There's either personal goodwill, which doesn't transfer, or there's any other goodwill is by definition transferable. And I'll show you the fact that it...
Which was used to be called inherent goodwill.
Well, that's a difficult term. There's a case I want to show you, if I may later, called Balloon Promotions, which talks about inherent goodwill being the benefit of the location, and adhering goodwill being the benefit of a business having been carried on at that premises in that location. And it says that adhering goodwill is a separate asset for capital gains tax purposes for a number of reasons. But in general, those distinctions are not considered to be extremely helpful anymore. But I do want to show you, if I made that case later. But at this point, we were simply talking in terms of the goodwill of a business.
There's personal goodwill and another form of goodwill. Let's forget the label for a second. Yeah. And the other form of goodwill is connected to the property, for want of a better expression.
Connected to the property in the business, in loose terms.
Goodwill only ever arises where there is a business.
Exactly. Yes.
Yeah, but it's connected to the property, not the person. You know, it's goodwill which isn't personal goodwill. Let's just put it that way.
As long as we have a common understanding of what personal goodwill is. And this morning I was hearing some suggestions that in my submission might not be correct, like a suggestion that, well, a brand might be personal goodwill. Now, personal goodwill in my submission is that bit of goodwill that's essentially down to the person. And when you buy a business, you don't buy the person. It may help if I can show you now something I was going to show you later. It's the capital gains tax manuals. It's at the back of the authorities bundle.
Oh, sorry, I don't quite understand. Personal goodwill is goodwill attaching to a person. In what sense?
It's the celebrity chef type example.
Right.
In the sense that it's because that individual has carried on that business. So it's
what about
particularly
a company? What about a corporate? I mean, a corporate person. A company is a person. What about the company carrying on the business? It's the reputation of the company, which
exactly,
will have many employees. I mean, that's personal goodwill for this purpose, isn't it?
No, the reputation of the company. If you buy the company.
No, you're not buying a company on any view here. You're not buying. Nobody's talking about buying shares in a company. You're buying the reputation attaching to the business which the previous company has established.
Yes, and if you buy the business, you would be entitled to use everything associated with that business, including any names.
A trading name.
That brand names would be a classic example of transferable goodwill. And I'm not talking about registered copyright now.
But when you say transferable goodwill, you see, you're not using that in the GN Guidance Note 1 sense, are you?
I'm using it in the sense that it's transferable as opposed to not transferable.
It's capable of being assigned. It's not something that goes with the property. If you want to become a franchisee of Pizza Express or whatever it is, you can get a license to use the name and the brand and the trading methods and so on. And in that sense, you will participate in their goodwill. But if you simply took a lease of the restaurant, you would not get that. So it's transferable in the sense that you can acquire rights to use it.
my lord may well have read balloon promotions even in light of the Pizza Express example, because that's what that case is about.
I know. That's why I gave it as an example.
Right. The point I was making earlier was an important one. If we could go back to the RICS guidance, because there's an assumption of a continuation of trading. There's an assumption that the business goes across. And so when you're talking about the trading potential and the future profit in the RICS guidance, you're doing so on the assumption that the trade has gone across. So if we could go back to that.
Back to VPGA4.
Yes, please. So I showed you paragraph 5.1. The assumption is of a fully equipped operational entity. At 6.2, you can see a trade-related property is considered to be an individual trading entity. It's typically valued on the assumption that there will be a continuation of trading. And we could also look at the definition of operational entity.
Sorry, where were you just reading there?
That was 6.2.
6.2, sorry, 6.2, sorry. Yeah.
And well, in fact, if we read 6.3 as well, so on the assumption that there will be a continuation of trading, when assessing future trading potential, the valuer should exclude any turnover and costs that are attributable solely to the personal circumstances or skill, expertise, reputation, or branding of the existing operator. However, it should reflect additional trading potential that might be realised. If we could look at the definition of operational entity.
So I'm not quite sure that I'm following this argument. The assumption that you're referring to is the assumption that trading will continue.
Yes.
And that assumption is applicable, is it not, whether you are assessing freehold value or market rent. That's the assumption on which the profits and the FMOP, or whatever it is calculated.
Yes.
So I don't quite see where this goes, because that assumption is built in to the profit valuation.
Yes.
Trying to suggest that it's something different from the leasehold interest. But if that assumption applies to the calculation of market rent, then it's already in there.
It's already taken account of insofar as FMOP is based on that assumption, yes. But the point I'm making is that transferable goodwill does not exclude, well, is the inverse of personal goodwill, in the sense that it is transferable. That's the basic point I'm making. And I wanted to show you the capital gains manual, which makes this exact same point. And that's the next step. Well, sorry, I'm in the authorities bundle. It's tab 15 of the authorities bundle.
This is an HMRC publication.
This is. It reflects well-established law and practice for decades. So it begins by saying goodwill is an asset. Then it gives the Halsbury law definition, which talks about value of the attraction to the customer. And then it says a new business will not have an existing reputation, but from the commencement of its activities will begin to generate goodwill, so that on a subsequent disposal of the business, as a going concern, we would expect that one of the assets comprised in the disposal would consist of goodwill. Then it says it's not defined, and then it quotes from Lord McNaughton, which you saw this morning, including the last sentence in that quote, is the one thing which distinguishes an old established business from a new business at its first start. Just pausing there, that was the importance or relevance of that part of the cross-examination with Ms. Rodriguez, in the sense that she's accepting that the difference in value. So if you've got a physically identical property, it will have a different value in the sense that if you're buying a property, a physically identical property will have a different value based on whether you're buying it purely the property with no business or property plus business. And that's because of the established use, which is the business and which is the goodwill. And if that's right, then the difference in value between the bare property interest with no business, no operation, and the property plus the operation, which is what VPGA is talking about when it talks about the assumptions, is the value of the established business, which is the goodwill. It's not the land interest.
Well, you might say it's part of the history of the property.
If you were going to buy the property and start your own brand new business there, then that would be its role. But if you're actually taking over and continuing the trading in the same way, then you're acquiring both the business and the property.
Well, that depends on reading continuation of trading as being taking over an existing business, which is not necessarily true.
Well, we'll see what Ms. Rodriguez said about that later as well, because all these points we explored below is the point, and we're looking at little snippets to try and, my learned friend, to try and build a case on. Sorry, if I can just return to the guidance then. You've got the Lord Lindley quote, which refers to this point.
So back to VPGA 4.
No, sorry, back to where we were in the gains manual.
Oh, yeah, right.
So goodwill has no meaning except in connection with some trade. And then it talks about goodwill is composed of a variety of elements, difference in composition. Then it talks about balloon promotions.
But situation must be part of the inherent value of the property, mustn't it? I mean, I know Lord Lindley is describing it as goodwill, but if you've got a shop in a high street as opposed to a shop in a secondary street,
the pure locality.
the location of the shop must add value to the shop and is part of its intrinsic value.
Yes, and then we'll see that in balloon promotions in a moment. The pure locality, but the carrying on of a business, which is referred to as adherent goodwill, is separate. If I could just then show you, first the balloon promotions, which I'll show you next. Then it talks about goodwill is inseparable from the business, in which it is generated and has its existence. When a business is disposed of as a going concern, any goodwill attributable to the business will be transferred to the new proprietor. So if you just pause there, what this manual is telling us correctly is that a newly established business doesn't have goodwill, but from the moment it starts trading, it acquires goodwill through operating. And then when you sell that business, a component of what you're selling will be the goodwill. Now compare that with what my learner friend now says. He says now, in order to have goodwill, you must be carrying on your business in an above average way. He says if all you're doing is carrying on the business in an average way, well then that's just the same way anyone else could carry on such a business. So it has no benefit, there's no goodwill. But that's clearly different to what's being said here, which is the correct position, which is that from the moment you start carrying on the business, even if it's only in an average way, you start generating goodwill. And when you sell that business, as happened in this case, you will be selling the goodwill. And that fits exactly in with what Lord McNaughton said. It's the one thing that distinguishes a business at new start from an established business. That's the goodwill. So even if you've been carrying on in an average way, the very fact that you've been managing to do it in an average way means you've got goodwill.
But the goodwill is attributable, as is indicated by this quote, to a number of factors. One is that people like the faces they meet and the people who conduct the business that they've become used to. The doctors, the dentists, if it's a dentist practice, say.
Yeah.
Another thing is that people might like to go to the premises to get the sort of services they get. It's a restful dentist practice at the particular, it's in a convenient location, close to work.
Yes.
I mean, that's an element of goodwill. It's an element of the attractive force of the business that is being carried on there.
To the extent that that attractive force arises purely from the location, I would accept that that's part of the value of the land.
Or indeed the, yes, from the location or the nature of the premises themselves. Is it a modern, well-fitted out building, or is it a climb 3 grotty flights of stairs?
Yes, you're describing the physical attributes of the property that would be the same irrespective of whether a business is being carried on.
No, not necessarily. Well, not necessarily. I mean, it's whatever makes people want to go to those premises, whether it's convenience, appearance, all manner of things that are associated with a particular building. I mean, all those attractive forces are part and parcel of the property, aren't
If it's to do specifically with the physical features of the building, then yes, I would agree with that in terms of its location, or physically, is it a sort of a newly furbished building, or is it 3 flights of stairs and a grotty back street? Then yes, that's the property. But insofar as it relates to the business and the benefit of it having had an established business carried on there, that then allows you to continue on that business, that is not the property, not the property interest. That's the goodwill of the business.
But it doesn't necessarily follow that continuation of trade carries with it goodwill, does it? I mean, if you are a fashion store and you want to get a shop in Bond Street, the fact that the previous fashion store has been there doesn't mean that you're acquiring any goodwill. You want to be in Bond Street because it's where all the upmarket retailers are.
So you're continuing the same trading, and as we'll see when I dealt with this point with Ms. Rodriguez, she was assuming that the customers went across, that the staff went across. In fact, she couldn't identify that anything that she didn't assume would go across the purchases. We'll see that in a moment.
All right.
May deal with. And just to finish off this point, we can then see that the guidance, the manuals deal with personal goodwill. And that's the third from the bottom paragraph. Any goodwill attributable to the personal skills of the proprietor, for example, the personal skills of a chef or a hairdresser, will not be transferred to the new proprietor. Advice should be obtained from the technical group if it is claimed that the goodwill attributable to the personal skills of the proprietor have been transferred. There's a distinction between the personal skills and etc. of the proprietor and those of the staff, because when you transfer a business, staff go across.
Yeah, and this section of the manual is talking about what? Transfers of businesses rather than disposals of interests in land.
This is talking about goodwill as an asset for capital gains tax purposes.
But that's a very limited point being made in that paragraph. Maybe it's the point you just made. I didn't quite catch it. But when they say proprietor there, they're talking about the vendor of the business, on the assumption that the vendor of the business isn't going with the business. In other words, it's assuming that the vendor, described as the proprietor, is retiring or emigrating or doing whatever, isn't it? Because the personal skills of the staff or people who are employed, and that could be a chef or a hairdresser, will be transferred to the new proprietor because they're part of the business. I mean, it's just making a very limited point, which is that, which may in fact not be true either, which is because the vendor may well go across actually and have an earn-out period. But anyway,
they may do. I mean, so the starting point for that type of goodwill is it's non-transferable, but then it says difficult cases may arise, refer to technical group, possibly to deal with the sort of situation my lord has in mind. But
it's actually pretty bog standard. many people, you buy the business from the vendor on terms that the vendor stays in the business at least for a year or two to absolutely ensure that for a period, people keep coming back, to the who are attracted by the person, and that's exactly what you do often. That's a small. I mean, but the point is, that is definitely what could be called personal goodwill in the clearest sense. That wouldn't attach to the property, wouldn't be part of the property value, i.e. the people. I don't think anybody's suggesting
no, exactly. That where this started was what is the distinction between transferable and non-transferable goodwill, and my submission is non-transferable goodwill means that sort of thing, personal goodwill, whereas anything that is transferable and it's goodwill, it's transferable goodwill. There's no further refinement of that.
So you have a species of transferable goodwill, put those words in brackets, which is different from the GN1 definition of transferable goodwill, and which is also not personal goodwill.
It depends how you understand the GN meaning of transferable goodwill. If it's limited to a subcategory of goodwill that is transferable, then yes, my approach would have to be broader.
Well, I mean, it's quite clear, isn't it, that GN1 talks about transferable goodwill as being inherent in the property and nothing else.
But it's not clear what it means, and if I can show you the next case, which is the balloon promotions case, because there is a distinction, well, it's been recognised as being a distinction between inherent goodwill and adhering goodwill. So that's tab 7 in the authorities panel. There's 139, paragraph 139, which is on page 122.
So the issue here was, could the taxpayers get rollover relief?
Yes.
And that depended on whether there'd been a payment for goodwill.
Yes, in part, yes.
Yeah. Page, sorry?
122.
Yes.
So this is in the context of submissions and the legal concept of goodwill. And you can see here we have the distinction between subparagraph 2, inherent, related to the location of the business premises, and free, related to the overall worth of the business, which was further subdivided by HMRC's manual. Between free adhering goodwill, this is the goodwill which arises not from the location advantage of the premises itself, but from the carrying on of a particular business which those premises have been or are specifically adapted or licensed, and inseparable goodwill. On the facts of this case, the question was whether there was any goodwill in relation to a restaurant business which had operated as a franchise, the Pizza Express franchise, before being bought by Pizza Express to operate in-house, along with the premises. It was held that there was such goodwill. That's at paragraph 248.
248.
Paragraph 248, yes. My lord. So if I'd like you to read 248 to 249, please. And then we can see HMRC's argument the adhering goodwill should be subsumed within the value of the property was rejected. That's at 258.
Yeah.
That establishes either it is of a nature that it won't transfer if you don't pass the property. That doesn't mean it can't be a separate asset. still, so you have transferable goodwill. Where I was before I went into that, dealing with the question of what is goodwill, we were looking at certain aspects of Ms. Rodriguez's cross-examination. If we could go back to the supplemental bundle, please. So I think I just shown you on page 279, behind tab 9, I've just shown you the bottom of 66, what I was about to show you. Yes, I've just shown you it. The next passage I'd like to show you, if I may, is at the bottom of page 67 of the transcript, the last question. So that 65%, i.e. the 65% the tenant gets at the step 4C, is what the tenant needs to encourage them to take those risks, because you need to see the corresponding reward if it goes well, do you not? Yes. So that is what the tenant gets out of it. But what you have done is you have taken that 65%, so you've taken the maintainable operating profit, deducted the rent, the 35%, that leaves the 65%. Yes. And what you've done is capitalize that, have you not? Yes. So you brought it back down to what the future income stream will be worth now. Yes.
Yeah. How far do you want us to read, Mr. Fass?
I see my lord's probably read quite some way. The next passage I was going to show you is the bottom of page 69. So you're saying, just for the interest in land, not for the business, the tenant pays 35% of the operating profit every year, plus a sum designed to capitalize the remaining 65% of the operating profit. Yes? And at the bottom of page 70, so when you have a profit rent, yes, and you turn that into a premium, yes, you capitalize it. For the period that the profit rent exists, yes, exactly. So you capitalize it to the net present value, and that is the premium for the property, yes. And in this case, for the 65%, you've capitalized it to the net present value, and that is exactly the same sort of calculation, yes, but you're doing it in perpetuity. Effectively, you're not putting any input on it. So this 65% that's been capitalized to its net present value is the net present value of what the landlord, what the tenant's supposed to get under the divisible balance. And Ms. Rodriguez is saying all of that is just for the lease, just for the land interest, which leads her, logically, to say that there's nothing paid for the business. Now, you can see that at 74. It's the third question on the page. He's not paying for the business, which is what you are saying. He's paying all of this, 100%, just for the leasehold. Is he paying nothing for the business? 100% of the initial years? Yes. Put it a different way then. Is the tenant paying nothing for the business? In my opinion, yes. That not strike you as odd. At the bottom of page 75. Last question. We will come to your experience shortly, I promise. But in terms of this guidance and what it conveys to the reader, in this case...
Sorry, wait, bottom of 75? Oh, yes, I see. Yeah, got it.
In this case, you, given that the leaseholds are dealt with in C, and C says nothing about a premium on top of the market rent, and this guidance does not envisage a premium on top of the market rent, does it? It does not describe a situation of that, no. Question, but it does not envisage it, does it? I do not know whether it has or has not been considered, but it does not allow for it, no. And then at page 78, first question on the page. My question was quite concise. Given the steps we have been through, given the terms of the guidance and what you've agreed in this guidance says, applying those principles, what this guidance says, the value of a market rent lease is nil, is it not? Answer, it's not provided for, no, within this guidance. Question, try again. Given this guidance and what we have just read, what you said you have understood, the value of a market rent lease, according to this guidance, is going to be nil, is it not? Answer, according to this guidance. I mean, that's HMRC's own expert agreeing that according to the guidance that both experts agree is applicable, the market value of a market rent lease is nil. In those circumstances, my own submission that the Upper Tribunal was Edwards and Bairstow wrong in reaching exactly the same conclusion cannot get off the ground. His own witness agreed to that. The next passage I'd like to show you, please, on page 82. First question. So the only goodwill that you've excluded in following this methodology is the personal goodwill, isn't it? Yes. And that is the non-transferable goodwill, isn't it? That's attributable to the special features of that particular operator. Maybe they're particularly good at running care homes, and the reasonable operator in the market wouldn't be. So that's the only goodwill you've excluded. And any other transferable goodwill must have been left in, mustn't it? Yes. That relates to the property. Well, let us just take it in stages. One, you agree that transferable goodwill remains in the valuation you've done. Agree? Yes. But if you're excluding any personal goodwill, yes. So you've excluded non-transferable goodwill, and you've left in the transferable goodwill, and you've assumed that the transferable goodwill should be attributed to the leaseholder. Yes. So when you're valuing a leasehold, in your view of the situation, you are valuing goodwill, aren't you? Transferable goodwill, which you say is part of the trading potential.
And that's the fundamental difference, isn't it? Is it trading potential, which is intrinsic to the property, or is it transferable goodwill?
Well, no, because transferable goodwill is trading potential. We'll see that in a moment. Right. In fact, it's on page 83. So if we could just read from the top of 83. Fine, but you just go through our steps again. You've excluded the non-transferable goodwill, and you've not excluded transferable goodwill. Therefore, it must still be in there. Agreed? And it is trading potential. Yes. And you've got a different name for it, but whatever we call it, it is transferable goodwill, isn't it? It moves with the property. Yes. Well, it moves with whatever. What is being transferred, which is the operational entity, isn't it? You're assuming the transfer of an operational entity. Yes. It's not the one I made earlier. She is assuming. We'll see more of that in a moment. The most we can say is that it moves with the operational entity. So it's right then that you must have been valuing goodwill, but you've just been calling it trading potential. Is that right? I've been valuing a trading potential, yes. If you want to call it transferable goodwill by the name that's in GN1, that has been now clarified to be trading potential, then yes. Are you saying a business like this doesn't have transferable goodwill, or is it just you prefer to use a different name? I prefer to use a different name. It's trading potential of property. But that's just a difference in name, isn't it? Yes. 84. I'm near the end of what I want to show you. Second to last question on that page. Just to encapsulate what I think you've said, is that should two physically identical properties, in terms of chattels or whatever else you have in mind you put in that trading inventory, if there was no business being carried out on one, but there was a business carried out on the other, the first one, the one without the business, would in your view be worth less than the one with the business. Agreed? Yes. My submission, obviously, on the basis of that, is, well, what's the difference? It's the business. we then go forward to 91, please.
So just pausing, and I appreciate I may be asking you the same question in just a different form, but if we've eliminated personal goodwill, and the goodwill is not goodwill which is part of the property.
Yes.
I'm struggling to find a neutral word to connect the goodwill to the property. But if it doesn't relate to, isn't connected with, isn't part of the property, and it's not personal goodwill, what is it generated by? What part of the business? You refer to business goodwill. What part of the business generates it?
That may be answered by the passage I'm about to show you. There's a number of aspects of business. I mean, you saw in Muller they said that goodwill can have a number of components and different ones will predominate in different cases, and it gives a list. But I explored this a little bit with Ms. Rodriguez, and that's on 891 in terms of what would be going across in this case. And that's on page 91 is the third question. The question was whether the existing staff framework and the knowledge of how the home operates and the procedures that has a value to a reasonable economic operator who does not have to come in and hire his own staff, check that they are competent, train them into the procedures they have in the home, and that has a value to a person acquiring. Answer, yes. I think a purchase of a property will benefit from that. Thank you. Would likely benefit from that. Question, exactly. It has a value and it is not inheriting the land. We've agreed that. And I think any purchase of land the property will have is likely to have a benefit. Well, will have the benefit of the occupants because they're under contracts that run with the property. It's likely to gain the property and gain the benefits of the staffing as well. I don't think there's a significant difference between a situation where a care home is being sold as part of a... At the bottom of the page, last question. So you do assume the customers will go across, the staff will go across, the supply chains will go across. Yes, most likely, yes. But you're assuming the business is not going across. What am I missing that isn't going across? I think they will follow with the land, with the purchase. Why would the staff give up their jobs? And then the second to last question on page 92. Have you, yes or no, assumed that those elements, the customers, the staff, and the supply chains, go across? I assume yes. I've assumed that it's very likely that they will. So, I hope that partly answers my Lord's question as to what beyond features of the land or things that sort of, at the risk of using a dodgy term, inherent to the land. What else is there? Well, there is the staff, the customers, the knowledge, the supply chains, all these things as to how you run a business. What is the business? And these are the things that are of value in any established business. It's like that they've got established staff.
Isn't that within the concept of personal goodwill? You limit personal goodwill to a proprietor. It's
the proprietor's special personal skills, yes, and I explored that with Ms. Rodriguez earlier. I was quite clear there as to personal goodwill is the special skills of the operator, particular operator, and anything else goes across. So the only goodwill she excluded was the personal goodwill, and that also fits in with exactly what's said in the HMRC manuals. Because personal goodwill is an inherently non-transferable, subject to my Lord's suggestion about what you actually get that person, the proprietor, to come with you. But you can see how HMRC are uncomfortable about that proposition in their manuals. And personal goodwill in the VPGA is defined as that which will be extinguished by the transfer. So you can see a number of important points that undermine my learned friend's case in this court were agreed, or at least teased out of Ms. Rodriguez during the course of her evidence. She agreed that she's assuming the business goes across in the sense of all the elements of the business. There's nothing that didn't go across. She agreed that the only element of goodwill that she excluded was personal goodwill, in the sense of the special skills of a particular operator. And she agreed that according to this guidance, which was agreed to be the applicable guidance, the market value of a the market rent lease is nil. We did deal with the land registry entries on page 98, where essentially Mr. Rodriguez agreed the point my lord made this morning, so we don't know. We don't know what assumptions have been made or what rents were paid in terms of whether it was a market rent, so they tell us nothing. Page 98.
Yeah.
I apologise for that being somewhat longer than you perhaps would like, but it's just to emphasise that you're seeing a very, very limited snapshot with much bigger picture painted over a much longer period in the Upper Tribunal, during which very important concessions were made by HMRC's own witness, effectively undermining their own case. Which makes, as I said, my learned friends Edwards and Bairstow challenge to the value of the lease somewhat impossible in my submission.
So in effect, I think what you're saying is Mr. Ellis was quite clear that he had valued the land and the business.
Yes.
When you cross-examine Ms. Rodriguez, she accepts that she has assumed that the business is going to the incoming acquirer of leasehold interest. Therefore, the figures agreed by the experts as the premium include value which is derived from the continuation of a business, which is value over and above the value of the leasehold interest itself. Whether you call it transferable goodwill or something else doesn't really matter. The only question is, what is the value of the leasehold interest?
Yes.
And that is the question which the UT have answered.
Yes. Yes. That's where I get to. But I have to deal with a number of my learned friends' points now, if I may. The first point I deal with is at paragraph 44 of my skeleton. The HMRC submit that the guidance supports them. And my learned friend showed you various definitions and made submissions on definitions, but the most fundamental error there is that he failed to deal with section 3, which is the actual method of valuation in the guidance. I've shown in my submission that far from supporting HMRC, it shows that the Upper Tribunal was right, and that's exactly what Mr. Rodriguez said. My learned friend says in this court that we don't attribute the whole of the trading potential to the landlord of the property. Well, that's different to what I recollect below, which is why the Upper Tribunal was addressing that submission. The Upper Tribunal dealt with this at 112 and 116. But you can see why this issue arose, because Ms. Rodriguez said, yes, the premium is the net present value of the 65%. And so if the tenant pays over 35% by way of market rent, and the net present value of the 65%, they paid over 100%. I.e. the whole of the trading potential. So it's no good my learned friend turning up in this court and saying, well, actually the 2.25 or whatever it was, the multiplier, isn't the whole because it's a 5-year lease. That's not the evidence we have below, and that's not the submissions I remember being made below. And the Upper Tribunal was absolutely correct to deal with that submission in the way it did. The logical consequence of HMRC's approach, in the sense of what Ms. Rodriguez said she was doing, calculating the net present value of the 65%, is, in economic terms, equivalent to a rent equal to 100% of FMOP. Because you can have any variation you like between rent and premium. You can have 100% premium, you can have 0% premium, and a market rent. If what you're saying, and this is what Ms. Rodriguez was saying, is that the landlord gets 35% in rent and the remaining 65% in net present value terms. That is no different economically to paying a rent every year of 100%. And so my learned friend's submissions, at least the evidence of Ms. Rodriguez, leads to the conclusion that market rent should be 100%. Whereas we know, and we've seen in the guidance, that there's a division between the tenant, between the landlord, in this case 35-65. And the reason for that division is to reflect the risks and rewards. Because not everything arises from the property. Somebody has to go and carry on a business. And the logic of HMRC's evidence is that the tenant should be prepared to hand over 100% of the profit an average operator would generate. In which case, why bother? Why not go and do something else? That's why the guidance doesn't say, right, you've done your divisible balance stage 1, now do a new division to reflect different risks and rewards. Just not there, because it doesn't make sense. Anything relevant to the risks and rewards, as between tenant and landlord, is captured in step 4C, the market rate. There's nothing else. My learned friend hasn't suggested anything else, because he doesn't deal with step 4C. I've already made the point that I make at 58 onwards of my skeleton argument. On HMRC's case, the concept of a market rent is meaningless, because that's the inverse of the point I've just made. If you're handing over 100% in net present value terms, then you can have any combination you like and say that's rent and that's premium. So the concept of a market rent loses all meaning, whereas the guidance clearly gives it a meaning and doesn't include a premium. And that in my submission is sufficient to dismiss this appeal, because my learned friend challenges the reasoning as to the application of the guidance. He accepts it's an Edwards and Bairstow challenge because these are the evaluative conclusions of the Upper Tribunal, the Specialist Upper Tribunal, on a question of valuation. And he doesn't, for the reasons I've said, come close to meeting that burden. His separate submission is to, well, that can't be the value of goodwill, because either goodwill doesn't exist or transferable goodwill doesn't exist, and or that's not how you would calculate the value of goodwill, doesn't arise because that's a separate point. As I said, in terms of the premium falls outside of the guidance. It's not calculating the value of the land interest, it's something else. And even if my learned friend was right in his submissions, it wouldn't matter, because it wouldn't change the fact that the land interest has been correctly valued at nil. Nevertheless, without prejudice to that submission, I deal with this issue in paragraph 68 of my skeleton onwards. The first point I make is that goodwill is an asset. And my learned friend seeks to make a distinction between goodwill and transferable goodwill. And he's saying transferable goodwill is not an asset. Goodwill is an asset, but with respect, I don't understand that distinction, because goodwill that can be transferred is transferable goodwill. Furthermore, we've seen...
But I think his point is that the UT and possibly the valuers are using transferable goodwill as meaning something that automatically went with the property. So in that sense, it was transferred with the property. One might think that if it automatically goes with the property, it's not really capable of being transferred any other way.
Yeah, I think
because it goes with the property.
That's one old question.
Well, there's 2 points to that. One, we've seen, when I explored this with Ms. Rodriguez, A, she confirmed that any goodwill, she confirmed that an operational entity is being handed over.
Well, that's a different point.
B, that personal, the only goodwill she excluded was personal goodwill, i.e. the special features of a particular personal operator, and therefore C, that she left in transferable goodwill, which is anything else. You've seen that. So in terms of what's transferable good, well, were there things other than sort of inherent features of the physical property included? Yes, there were, and then we saw exploration of what they would be in terms of staff, supply chains, knowledge of other business, etc. later. All that was assumed to go across and had benefit, had value. And that's the difference between an established business and a non-established business.
So, if I can just pause to pick that point up, because I think I've just understood this, that if you go to, that it was common ground that personal goodwill had been excluded. Personal goodwill as defined in 2.9 on page 209 of the supplemental bundle, which is the value of profit generated over and above market expectations. I'm not entirely sure what that phrase means, but anyway, that would be extinguished upon sale of the trade-related property. Right. I think, as I understand it, you're saying the value of the profit that would be extinguished on sale of the trade-related property is the value of the profit which relates to the proprietor, let's say, who isn't going across in the classic case.
Yes.
But you say that there is a proportion of the profit that would be made by a new reasonable operator, the reasonably efficient operator, that would be attributable not to the fact that they're buying the property, but would be attributable to the fact, let's say, that they are buying, in inverted commas, the people, the know-how, because there's a workforce that does transfer, that is not extinguished.
Yes.
So you're saying, in fact, if we're thinking about it, there are 3 component elements to the value of the profit. There's some value of the profit which does attach, is properly regarded as part and parcel of the property. It's in a good place, it's nicely furnished, people love to go there. That does form part of the profit.
It arises.
And then there's some part of the value which you must eliminate, which doesn't go across, because the reasonable operator can't be assumed to have it, and it isn't going across, even though if it has generated part of the profits in the past, because it's personal to the previous owner.
Yes.
And then there is something which is not extinguished on sale, which does go across, which isn't in any way related to the property, and you say that's things like the know-how of the staff, and that is transferable goodwill in a different sense than was used in Guidance Note 1. Guidance Note 1 does appear to tie everything to the property, but it's goodwill which will not be extinguished on sale and therefore will go across.
Yes, which is there.
And you're saying that that is what the Upper Tribunal found was, if I can put it again very broadly.
Yes, because I mean, the tribunal considered this in a number of different ways. One of which is that way, but the other is to compare the hot start and the cold start, in the sense that you saw Ms. Rodriguez accept it, and the Upper Tribunal obviously was aware of this evidence and recorded it in the section, that you would pay more for a property that has a business when you're getting the business as well than you would for the same property, physically identical in every way, without the business. because for the very reason that you're getting the know-how, the staff, the supply chains, all those things that make it easier to continue running a business. If you don't get those things, what have you got to do? You've got to go and hire a load of staff. That costs money and time. You've got to find suppliers. That costs money and time. You've got to work out how to run a care home business, unless you already know how to do it, and set up procedures. So there's a benefit, as Mr. Grieger's accepted, to getting all those things. And it doesn't come from just getting the land. You could have a physically identical property without any of those things. You could have a physically identical property that has an established business that the shutters come down the very day you buy it, so you get none of that benefit. But she's assuming, in accordance with the guidance, that an operational entity goes across. And that operational entity includes the things my lords just referred to, which she accepted had value, and which do not.
Well, isn't there, I mean, there may be a difference, may there not, between taking the reality that there has been an operational identity on the site and assuming that the operational identity passes to the new proprietor. And I think your point is that Ms. Rodriguez was assuming that the operational entity passed to the new proprietor.
Yes, yes, she was.
Not simply that there had been an operational entity on the site.
Exactly. Which is why you get this additional value. I mean, it's look at it a different way, if I may suggest, because this is about trade-related properties. There are other properties that are not trade-related, and they may be carrying on similar businesses. So, for example, dental practice is a very common type of business where you have sales of practice and goodwill. It's very well recognized that there's a substantial element of goodwill there. How can the existence of an asset of goodwill vary depending on whether the property happens to be particularly well adapted to the carrying on of that trade? So if a dentist carrying on their dental practice from a particular property in a particular place, probably for many, many years, builds up a client base, has a reliable set of dentists and associate dentists and hygienists, if they sell that practice, they will receive an element of goodwill, and that's well established. Cases talk about it. I did one a few weeks ago. The proposition before you from HMRC is, well, if that property happens to be a trade-related property, which means no more than it's particularly well adapted to carry on that particular type of trade, suddenly there cannot be an asset of goodwill. Suddenly everything you otherwise would have attributed to goodwill, the benefit of the customer list, the benefit of the existing staff, all of that is no longer a separate asset of goodwill. Somehow we have to bring this all into the value of the property, and we have nothing left other than a property interest, and everything's paid for the property interest. And that just can't be right. How can the difference between very valuable goodwill and no goodwill depend on how well adapted the property is to carry on a particular type of activity? Because that, my learned friend said, ultimately their argument in the tax case is there's no goodwill at all. And the logical consequence of that is that, well, everything must be for the lease. That's why they're here, that's why they're arguing. But as I said, that cannot be right. It cannot be the case that how well adapted a particular property is the difference between substantial goodwill and no goodwill.
Yeah.
The next point, if I may, is at paragraph 75 of my skeleton argument, which is that a business running the way an average person, a reasonably efficient operator would run it, can have goodwill. And that follows from authority. The Muller case said it's the difference between an established business and a newly started business. Nothing is said there about it being about a business that's run in an above average way. You saw the same thing in the HMRC manuals. It's the difference between an established business and a non-established business. And that makes perfect sense, because even if I'm running a business in an average way, even if I'm running my solicitor's firm in a particularly average way, I've got an average number of clients, we're doing average quality work, nevertheless, somebody will buy that business off me at a price to reflect the benefit of being able to take over the average business I have built. because I've still put an average amount of work in that's built up an average amount of goodwill benefit that somebody can buy. And there is a big difference between that and having to build what I've built from scratch. That's why people pay for average businesses. You will pay for a below average business as well. So the suggestion that in order to have goodwill, you must have run it in an above average way, and therefore this type of business, we're assuming, cannot have goodwill, is wrong. And the reference to Planet Art LLC is with respect misplaced. I've dealt with that in my skeleton argument.
Yeah.
I don't think I need to say more about it. Point 5 at paragraph 82.
But is the significance of the REO that what we are dealing with is the hypothetical profit that would be made by a future business?
Yeah.
And it is difficult to see how a future business has goodwill at the moment when it starts. Now that may be going back to the difference between a cold start and a warm start, as you described it. And you say that Mr. Rodriguez assumed a warm start. And maybe if you're valuing a land interest, then you value on the basis of a cold start. That's possible.
Yeah.
But yeah.
This is point 5 in my skeleton argument. And my learner friend dealt with paragraph 85, which makes the point that even if HMRC are right, even if this way of calculating a premium doesn't result in a figure for the actual goodwill, it doesn't lead to the entirely different conclusion that in fact this figure is part of the value of the land. I've already made my points on that. See the guidance. But HMRC are wrong. My learner friend didn't deal with the range of 86. The market value of an asset is based on its value to a hypothetical purchaser. So in any situation where you're working out the market value of an asset, you are necessarily assuming and calculating its value to the hypothetical purchaser, not the value to the actual current owner. Accordingly, where the value depends on the profit you can generate with the asset, one does not use the actual profit generated by the current owner, if any, but the hypothetical profit that a purchaser might reasonably be expected to generate from the asset. This is absolutely fundamental to the well-established test for arriving at the market value, is that you're assuming a sale in the open market to a hypothetical purchaser. And the value to a hypothetical purchaser will depend on what they hypothetically will be able to do with it. If they can only achieve a lower profit, because part of the profit is attributable to your personal qualities that won't be coming with it, they're not going to pay for that. On the other hand, if I have an asset and I'm not using it to its full potential, but the market knows its full potential,
yeah,
they may pay more than I'm currently generating from it. So the key point is you do work out the value of actual assets by considering the hypothetical profit they could produce for hypothetical purchases. That's just how you do it. So I say, well, it's the same when it comes to goodwill. Point 6, paragraph 94. So, I mean, there's much talk of GN1, but the Upper Tribunal didn't just consider Guidance Note 1, it also considered the cases, including balloon promotions, which, as I've shown you, specifically recognizes that goodwill, as they call it, adhering goodwill, is a separate asset, even if it's of a nature that will only transfer if you transfer the property. And we can see that the Upper Tribunal considered that. Paragraph 100 of the Upper Tribunal decision. Sorry, yes, paragraph 100. The suggestion that the only possible basis for identifying the existence of transferable goodwill was Guidance Note 1 is wrong. Submissions were made and considered in relation to this. Because this was part of a somewhat ironic now, because my argument, one of my arguments, was that, well, actually, this is a legal question, in the sense that it's already been decided that there's separate goodwill in relation to such properties, and HMRC are trying to relitigate it. HMRC, on the other hand, were arguing that this was merely a question of valuing the leaseholds in accordance with the guidance. You can see that at paragraph 98. The Upper Tribunal said we see no conflict between the parties' positions, which we think are both correct. What constitutes the land asset to be valued as a matter of law, but how much the asset is worth as a matter of fact. The appellant seeks to show that law recognises goodwill as a separate asset distinct from the land. That is so, then the valuation made on the basis that goodwill is part of the land would be wrong in law. Then it refers to the cases I've just shown you. And then 102, we do not accept that the law as to what is to be treated as a separate asset has been determined so as to bind this tribunal. We have due regard to the cases referred to by the appellants. We do not accept that the respondent is barred in law from arguing that the agreed valuation relates solely to the leasehold interest. The respondent does not refer to adherence or any good of the goodwill, but expresses its argument in terms of what trading potential means and how it should be reflected in the value of the leasehold interest when using the profits method of valuation. And that seems to us to be a matter of fact and valuation principle rather than a matter of law. Well, now my learned friend says it's a point of law in this court, and that the Upper Tribunal got it wrong. But actually, the Upper Tribunal considered the case and said, well, look, we see what they say. They recognise the existence of goodwill, but we need to consider as a matter of fact and valuation principles what this represents in the present case. And that's what forces my learned friend to mount an Edwards and Bairstow challenge. But we've seen the authorities. I've set them out in my skeleton argument at paragraph 101. There's a question as to whether permission has been granted on this aspect. In my submission it hasn't, but I'll leave that for the court to consider. But if it has been granted, then we have to apply the ordinary principles. In particular, Joshua, at paragraph 102. It follows, in my judgment, that for a question of law to arise in these circumstances, the appellant must first identify the finding which is challenged. Secondly, show that it is significant in relation to the conclusion. Third, identify the evidence, if any, which is relevant to that finding. And fourthly, show that the finding on the basis of that evidence was one which the tribunal was not entitled to make. What is not permitted, in my view, is a roving selection of evidence coupled with a general assertion that the tribunal's conclusion was against the weight of the evidence, was therefore wrong. A failure to appreciate what is the correct approach accounts for much time expensed that was occasioned by the appeal to the High Court. And then when you go through, my learned friend has three limbs to his Edwards and Bairstow challenge. The first was some sort of suggestion that, well, the experts were agreed on this point, or at least, in the end, it seemed to be that my witness agreed that his witness took a different view to my witness in terms of what this premium represented. But that can't possibly mount a Bairstow challenge in the sense that there's plainly evidence, at least my evidence of my witness, upon which the Upper Tribunal's conclusion can be based. But in fact, as I set out again at 103, and I showed you when we went through the evidence, his witness agreed with me. So that's the first point. The second point, 105 of my skeleton argument, well, he relies on the comparative transactions. But, well, my Lord's questions undermined that reliance, and if you read the section in Ms. Rodriguez's evidence, that undermined it. We simply don't know what assumptions were made. No idea. And then they make a general economic argument. Then HMRC's opinion, an open market participant would pay more than the market rent. Well, that's not evidence. That doesn't tend to show that this conclusion was outside the range of possible conclusions in the evidence before the tribunal. And what we've had is exactly that. We've been shown little islands of evidence, not the whole evidence. I mean, you didn't see any of the stuff in Ms. Rodriguez's evidence that I took into, which fundamentally undermines my little friend's. But we've seen little passages, and we're set, on the basis of that, we're told to conclude that the Upper Tribunal's evaluation of the evidence, after hearing evidence for a day, reading numerous pages of submissions considering all the evidence, is irrational. And that, with respect, is simply outside any possible range of reasonable arguments here, because it just doesn't get off the ground in Edwards and Bairstow. So, my lords, unless there are further questions, those are my submissions. And if I just may turn my back for one moment just to check. My lords, thank you very much for your attention.
Can I just want to go back to what the experts agreed, if I may.
Yes.
They agreed fair maintainable trade.
Yes.
They agreed the fair maintainable operating profit.
Yes.
They agreed that you should adjust fair maintainable operating profit by deducting the passing rents.
Yes.
And then they agreed that the profits method of valuation requires the rent adjusted FMOP to be capitalised using a year's purchase. Now, does the error which you say Miss Rodriguez made come in the calculation of the fair maintainable trade, because she is assuming that the staff and the customers and the supply chain go over and thus inflate the fair maintainable trade?
No.
Where do you say the error, in which part of this sequence do you say her error was?
In assuming that the result of the last stage is the property rather than the goodwill. This was dealt with by the Upper Tribunal, paragraph 94, my lord.
Right.
Although Mr. Ellis accepted, because there was an argument from my learned friend below, that, well, actually, Mr. Ellis has accepted his argument. And they said, although Mr. Ellis accepted that the valuation is related to leasehold interest, we do not think that constituted acceptance of the respondent's position. It is clear that the experts have different opinions about what the agreed valuations represent, and at no point did Mr. Ellis say otherwise than that the valuation reflected business goodwill. His instructions were to provide his opinion on the market value of the leasehold property and business. He accepted the term leasehold interest, but did not attribute the same refinement and meaning to it that Ms. Rodriguez did.
Sorry, let me just see if I can elucidate what I'm getting at. Leave aside leases for the moment.
Yes.
And take a freehold.
Yes.
Where you don't need to trouble about deducting the rent.
Yes.
You assess the fair maintainable trade.
Yes.
You then assess the fair maintainable operating profit, and you capitalise it.
Yes.
If you do that, have you or have you not included goodwill? In the sense that you're using it, transferable goodwill.
This is a submission I made to the Upper Tribunal. So, depends on the multiplier you use in that case.
Why?
Because as my lord said this morning, you normally value a business, just looking at a business to get the property based on its profit multiplied by a multiplier.
Yeah.
Let's call that the goodwill. So you value goodwill of a business based on multiple of profit. If you have a property that happens to be a trade-related property, where you also value the property on the basis of profit times a multiplier, then it follows that depending on the multiplier you use, you can either end up with a value of the property, business, or the whole. So let's say you might say, well, the multiplier to apply to the property is 7 times FMOP. The multiplier to apply to the business is 2 times FMOP. And so if you applied a multiplier of 9, you would end up with the whole. If you applied 7, you'd end up with the property. If you applied 2, you'd end up with the business, the goodwill, which is why the leasehold case actually nicely illustrates this distinction between the goodwill and the property. Because here, you don't capitalize anything. You just find the market rent based on the divisible balance.
But in calculating fair maintainable trade,
Yeah.
at least on the basis that Miss Rodriguez did it, she was assuming that the staff, the customers, the supply chain would all be acquired by the new purchaser.
Yeah.
You were putting to her in cross-examination that necessarily means that she was including goodwill.
Yeah.
Now, if that is so,
Yeah.
and if goodwill, in the sense that you are using it, should be excluded from the property valuation, is that not where you say the error came? That the FMT ought to have been lower? And if that's not what you say, I find it difficult to see why an adjustment to the YP makes any difference if you compare and contrast a freehold valuation with a leasehold valuation. And I don't think that the guidance in VGPA 4 tells you to adjust the YP according to whether you are or are not valuing a going concern or stripping out goodwill, because all it says is capitalised at an appropriate rate of return reflecting the risks and rewards of the property and its trading potential. That's what it tells you about the YP. It doesn't say, oh, and if you're including goodwill, you knock it down even further.
It wouldn't need to, because it doesn't tell you what the YP is. It assumes you're going to find out in a different way. So it doesn't go so far as to tell you what the YP is. And if you're just trying to work out the value of the property, you would use a lower YP, because the business has an element of value. Because when you're selling a business, how do you value it? You base it on a multiple of turnover or profit. What that multiple is depends on comparable transactions for comparable businesses. If you buy property plus business, you'll pay more than if you get just the property. And that's how you end up with different YPs. If you're getting the business as well, as Ms. Rodriguez has said, you're getting something extra, getting some benefit, and that's what you're prepared to pay for. So the error is not failing to exclude goodwill at the FMT stage. The error is going beyond the guidance, which says calculate the market rent and stop.
Yeah.
And in terms of both experts work on the basis that you assume the business is going across, because that's what the guidance says to do. I mean, we could quibble about whether there's an alternative approach to valuing it which wouldn't assume it going across, in which case you'd end up with lower values, but possibly different multiples. But that's just not what the guidance says. And so you're necessarily valuing a turnover that does include the element of goodwill, but you're not giving all of that goodwill to the property. Well, you're not giving the benefit of that to the property interest. You're recognizing a separate benefit in the same way you would if you were just buying a business with no property. So if you were just buying a business with no property, let's say I had a perfectly formed care home just down the road, and all I wanted actually was the staff and the customers and the supply chains and somebody who knows how to run it. I could go along enough to buy that and transmute it down the road into my identical property, and I'd have to pay a price for that. That's a fully formed business. I don't get the property in that situation, but I do get the business. Take it down the road to my care home. And that might be unlikely in real terms, but it illustrates that there's a distinction between getting the property and getting the property.
So it's all in the YP.
And for the freehold, it's in the YP. For the leasehold, it's actually very simple, because you just...
No, I follow. I'm just thinking about the freehold.
Yes.
So you calculate the FMT in the way that Ms. Rodriguez did.
Yes.
There's nothing wrong with that.
Yes.
And then you've got to choose the YP to, as it were, strip out
Yes.
the transferable goodwill, to use your phrase, in valuing the bare freehold interest.
Yeah. Well, you're finding a value for the goodwill, and how do you value goodwill? It's a multiple of profit. It's not you stripping something out. It's just you're applying the correct calculation to work out that element. And equally, for trade-related properties, we are told this is how you value it by reference to profit and a multiple. And that's just how you come up with a value. And if we were to adjust FMT and do a different approach to valuation, as my lord has suggested, then you probably end up with different multiples. But given that it's an industry standard, they've obviously adopted it for whatever reason they think appropriate. It's not for us to tell them they're wrong. But it does mean that in a situation where you've got a business and a property, then depending on what multiple you use, you could end up with a value for the property, the business, or the whole.
Yeah.
And again, this is perhaps where it's relevant to remind ourselves that the Upper Tribunal is a specialist land chamber. And it would be surprising if at least I, as a lawyer, was able to come along and understand these things better than they do, or if there was some gaping hole in the valuation methodology that lawyers spotted and the specialist land chamber was completely unaware of. We should probably start with the assumption that the land chamber knew what it was doing in this rather expert field, having heard all the evidence and looked at all the documents. Unless there's any further questions,
I don't think we've been shown or taken to paragraph 106 of the tribunal's judgment decision. Maybe we have been, but is that a correct summary of the question that they actually were asking themselves? Picking up from the third line, in this case we need to consider whether the premium resulting from its application, that is the profits method evaluation, excluding any personal goodwill, which we looked at, is solely indicative of the trading potential inherent in the leasehold interest, or whether it also reflects other trading potential originating from the business conducted on the property.
That's certainly one way of looking at it.
Because the answer that they gave is that it reflected other trading potential originating from the business conducted on the property, and it's not solely indicative of the trading potential inherent in the leasehold interest. Is that the way to understand the question they in fact were addressing, or they thought they were addressing, which they then answered in paragraph 117?
Well, fair inference that if they set out a question and then purported to answer it, that they purported to answer the question they set out, yes. I mean, I would say, go back to the point I made near the beginning, that the actual question referred to them was strictly the value of the land lease. And they answered that by applying the guidance that was agreed to apply. They did that between paragraphs 107 and 110. Having done that, they did go on to decide, if not the lease, what does the premium relate to? If not the property interest, what does the premium relate to?
Yeah.
In strict terms, I submit they didn't necessarily done that, but they did. They reached an answer that, in my view, was the correct, my submission was the correct one, for all the reasons I've given. But I think it would be wrong to analyse 106 and 117 with no regard to the actual application of the valuation method, the actual guidance that was agreed to apply, i.e. section 3 of VPGA 4, which is what is done in 107 to 110, because that actually gives you the direct answer to what is the value. And as we saw,
yes,
Mr. Rodriguez agreed with that.
Okay, but that is the profits method evaluation.
But that's what I say, because profits method evaluation is a method evaluation that includes or is based on the profits. And as I said, depending on how you operate,
it's paragraph 3. That's the heading. That's the title of it. I mean, that's what it is.
Sure, but profits. But my lord, as you suggested this morning, when you're valuing a business, you value it by reference to its profit, and so that is also a profits method of valuation. And that's what I was submitting in response to my lord's question. So that depending on how you operate it, you can end up with the value for the lease, or property, value for the business, or value for both.
Yes.
Unless there are any further questions or the submissions.
Thank you very much, Mr. Firth.
Thank you very much.
Yes, Mr. Brinsley-Stockham, any reply?
My lord, I do have a few points in reply. I will try and keep it as brief as possible, but there are a couple of important points that my learned friend raised, so I'll need to address all of them. Just starting with my learned friend's introductory points. My learned friend sought to say, well, this is an evaluative question from an expert tribunal, and you should accord it the necessary deference that it deserves. In my submission, that's not quite right.
Well, either they made an error of law or they didn't.
Well, indeed, but in my submission, this isn't a sort of evaluative question, an evaluative factual question. What we really have here is a question of principle. All of the facts, as we've seen, were essentially agreed, both the underlying facts and the valuation method. Really, all the Upper Tribunal was doing was picking between two answers as to what the valuation referred to. So, in my submission, it would be wrong to categorise this amongst the kind of evaluative questions of whether X activity constitutes a trade, where you've got lots of factors to take into account. This really is a question of principle. Second point, my learned friend suggested that my case is entirely reliant on an Edwards and Bairstow challenge. That's not right. The arguments in respect of goodwill is just a classic error of law in my submission, that the tribunal has wrongly categorised and analysed the asset to which it attributed the agreed valuations. Now, I do rely on an Edwards and Bairstow challenge in respect of paragraph 110, and we saw the market rent point. You have my submission that the statement that it reflects the trading potential available to the tenant is simply wrong on its face. So my submission that's just plainly, factually incorrect. One further point that occurred to me, further to a point that my Lord Justice Snowden made, was, well, to the extent that the tribunal is relying on guidance, if it manifestly and incorrectly applies that guidance, in my submission, that would in and of itself constitute an error of law. Now, whether one views that as a classic error of law on its ex facie, or whether it's...
The problem there is that you run into the refusal of permission on ground 2-3.
Well, but if it goes to the question of whether or not the asset is correctly regarded as goodwill, or whether the valuations correctly are regarded as of being of the leasehold interest.
Sneak it into ground 1.
I'll do my best, my lord. Yes, but all I would say is, if it is manifestly clear that the tribunal has made that kind of an error in applying the guidance, in my submission, that would be sufficient for an error of law. And if you find there is an error of law, then obviously you are then left with the question as to whether to remake the decision or not. Obviously, you're not required to. That's a discretion. But in my submission, once you have that foot in the door, it's then open to you to decide the point in the manner that you consider is correct. Yeah. The third point I need to address is the point that my learned friend made concerning the fact that there is no specific provision for a premium in VPGA 4. Now, the first point to say is there's nothing excluding such a premium. So the highest that it can be put is that there's no specific provision for it in VPGA 4. Second point, VPGA 4 starts with caveats. So, my lord, if we can go to VPGA 4, supplemental bundle, page 207. There is a grey box at the top of that page. And you see there, my lord, first bullet point. Sorry, my lord. Tab 8, page 207.
Yes.
Grey box at the front. Up at the top, first bullet point, this guidance cannot cover every circumstance. It says members are reminded that this guidance cannot cover every circumstance, and they must always have regard to the facts and circumstances of individual assignments when forming valuation judgments. So there is that caveat. It is fair to say, as my learned friend observes, that in relation to leasehold properties, VPGA 4 provides for the determination of a market annual rent in 4C. That's what it's considering and what it provides for. But we've seen that both experts agreed that the granting of leasehold interests in care homes is not a usual or normal transaction. It's also in the underlying Hinders report. It says there's very few instances of this type of transaction. And here we have the additional factor that it's between connected parties. So in my submission, this is not a standard valuation situation, and it's not perhaps surprising if it's not directly addressed by the guidance. You already have my submission that the consideration for leasehold interest can plainly be an annual rent, a premium, or both, elements of both. So there's nothing conceptually difficult about HMRC's approach. But more importantly, and my lord, this is a point that, that you addressed, both experts agreed that there was a need to apply what is in effect a modified form of step 4A to determine the value of the leasehold care homes. So they both used the figure of FMOP after rent. And if I can just take you to the joint statement, just to sort of show that the fact that they were clearly using this and using it in a way that they were intending to. It's at 192 of the joint, page 192. So page 192, paragraph 2.6.4, and also over the page at 2.6.10, this is the joint statement of both experts. They're saying, in applying a multiplier to the leasehold FMOP, so it's almost a concept that they're referring to in and of itself, the FMOP of the leasehold. Now that's obviously FMOP after rent, the figure that they go on to multiply. But in my submission, that plainly shows what they're doing is applying a modified version of 4A to arrive at.
Saying that more clearly perhaps in 2.6.3. When considering the valuation of the leasehold interest, it is agreed that the FMOP on this basis is whatever it is, which is assessed by deducting the passing rent and so forth.
Well, the entire statement is framed in terms of the leasehold interest, and I perhaps can't rely on that because that was my primary case before the Upper Tribunal, that they just agreed a value for the leasehold interest, and the Upper Tribunal didn't accept that. But nonetheless, they are clearly considering this is the leasehold FMOP. So they're saying this is maybe a slightly different version of FMOP, but it's the one that we're applying. And my lord, the point that you made was if you had a leasehold with a sub-market rent, if you were asked to value that, how would you do it? In my submission, it's absolutely right to say, to find a capital value for that leasehold, you would have to apply a modified form of 4A. Possibly, you could say it's a modified form of C, but you'd still have to capitalise that figure. So you'd still be doing something that is not specifically provided for in this guidance. And that's entirely consistent with the fact that the caveat we've seen up front says, look, this doesn't apply to all circumstances. Essentially, you have to apply the principles that are in the guidance to arrive at the correct valuation. And that ties into the fact that here, as we've seen, both experts agreed how to do that valuation. They both considered that they were applying the RICS guidance to arrive at a valuation. They agreed the method, they agreed that they had significant market value, and they agreed what the valuations were. And most importantly, they agreed that those valuations represented trading potential. And as we've seen, trading potential is specifically defined as being inherent to the property. So those are my submissions on the absence of a specific provision for a premium. Next point, my learned friend relied on 6.2 of VPGA 4. That is at page 211. And my learned friend said, well, a trade-related, 6.2, a trade-related property is considered to be an individual trading entity and is typically valued on the assumption that there will be a continuation of trading. And in my submission, that is a continuation, that's an assumption that there will continue to be trading. It's not an assumption, and can't be an assumption, that it's the same business that will continue to trade. And the reason we know that is because we know you assess the profits by reference to how an REO would run the business. And actually, conceptually, when you're valuing here the care homes, but any trade-related property, the actual business that's being carried on the land is almost entirely irrelevant. Now, it's used perhaps as a starting point at which you might derive figures for FMT and FMOP, but the figures are irrelevant to the valuation. They could be, the FMT and FMOP figures could be significantly higher, they could be significantly lower. If they were significantly higher, then in my submission there's plainly no goodwill.
It does seem a bit odd though, doesn't it? That you assume that you acquire the staff, the customers.
I need to come on to that one because that wasn't assumed at all. I have to actually show you the transcript, but that is not what Ms. Rodriguez assumed. The point was that it comes back to the trading history point, which is that if you know you have staff there, if you know you have clients and a market nearby, then you are much better able to form a view as to fair maintainable trade, fair maintainable operating profit. You know you can get staff in, you may be able to get them cheaper, and you may reflect that in FMOP, but there was no assumption in this case that the business transferred over. I'll show you the transcript, but what Ms. Rodriguez said is that she assumed it was likely that they would, because that's exactly what an REO would assume. Someone in the market would say, well, look, they've got staff in place, I could probably take them on. And that's a relevant factor when you're seeking to determine what profits you could generate from the land. But there is no assumption that it's the land and business that are being transferred. Just one further point on that 6.2, the assumption of continued trading. What that's really dealing with is the point that you don't just assume the property closes. And you might have seen that before the Upper Tribunal, Mr. Ellis prepared a variation on the basis that there was no business at all, the shutters had come down. And the Upper Tribunal rightly said, well, no, there was a trade going on the day. We have to assume that some form of trading would continue, albeit trading by an REO.
So, I mean, that's quite important. This is quite an important area, because if you're saying the assumption about the profit that the FMOP that would be obtained by an REO is on the basis of an REO bringing their own staff with their own contacts. Yes, they may have the same number of care residents, because that's the nature of the property. It's got 50 rooms or whatever. But you assume that the REO is having to equip the home?
Well, no, because that comes back to the point, and I need to show you the definition of operational entity, which my learned friend referred to but didn't take it to the definition of. The trading inventory is assumed to be in place in an operational entity. So no, you're not assuming that they have to buy all the inventory.
No, not the inventory, but it doesn't.
And I don't think you're assuming that all the staff disappear, or that they all go across. You have to take account of what the REO would make of the situation.
Absolutely, my lord, yes. And that ties into the next point I was going to make, which is that... Oh, sorry, my lord.
Sorry, but it is your point. The operational entity, curiously, doesn't include the staff.
No, it doesn't. And the reason for that is that questions like, what are the market, what market for suppliers there, who are my potential suppliers, what staff are available, those are things the REO would factor into the question of what FMT and FMOP he could generate. So, my lord, I assume you're looking at the definition of operational entity in 2.12.
2.8.
2.8, sorry. Yes. But you can see there specifically, it's the legal interest in the land and buildings, the trade inventory, and the market's perception of trading potential. Now, obviously, there's a question as to...
It excludes, it says it excludes consumables and stock in trade, which I sort of understand. They're just the supplies on the shelf.
Indeed.
But the one group of things that are not mentioned there are people or contracts.
And in my submission, the answer to the reason for that is that if you had let's assume you had just got standard contracts with employees, standard supply contracts, that would simply be reflected in the profit that an REO would generate. If you had particularly advantageous, let's say you managed to get some really good block deal with a local council that was paying you above what you what an REO might expect to generate, and that contract would end. There, let's say it was tied to the particular operator. Obviously, one can get into slightly overly engineered hypotheticals, but assume there's a very valuable contract for your services. You don't factor that in, because that would be an amount above and beyond what an REO, assuming the REO would not be able to benefit from it. And that value, in my submission, that amount above and beyond what an REO could generate, is personal goodwill. And I need to come on to that point as well, because it's a point that my learned friend made. But just while we're on that point, paragraph 2.13, definition of trading potential, I'm not going to go back to it because I've already been there twice, but it is specifically provided that the trading history in the market conditions prevailing is an aspect of trading potential which, as we've seen, is inherent to the land. And in my submission, all of those questions about how much have you been historically paying the staff, how much have clients been paying, what supplies have you had, all that factors into the trading history. So as my Lord Justice Lewison suggested, all of those facets, although you might not say they're part of the physical infrastructure of the building, they do, for these purposes, form an aspect of the land. They are regarded as being inherent to the property, in my submission. I should briefly deal with balloon promotions. My learned friend took you to it. I can make 4 quick points on that. First is, it's obviously a decision of the First-tier Tribunal, so it is of limited authority. Second, in that case, the value of land was specifically not in issue. So there was no question there of what the value of the particular leaseholds that the businesses were operating from were. And you can see that, my lord, if you go to, it's page 115. It's said in various instances, various places in the decision. Page 115, it's paragraph 105. Mr. Watson's instructions, that's HMRC's expert, were that the respondents did not challenge the apportionments for land and buildings and fixtures and fittings in the sales agreements between Pizza Express and the appellants. The respondents accepted that these figures reflected a fair value for the assets bought. So in that case, there'd been a payment of £25 million, I think, in total. And the question was, do you allocate that to goodwill, or do you allocate it to effectively the cancellation of the franchise contracts? Now, there were some arguments in the case about whether goodwill had been subsumed within land, but fundamentally, the actual valuation of land in that case was simply not an issue, it was common ground. Final point from that case, just to take from paragraph 169, now my learned friend did highlight that there are some references in there to inherent and adherent goodwill, and the Whiteman case that talks about cat and rat.
Sorry, where are we? 169?
169, page 125.
Yeah.
What the First-tier Tribunal said there, for what it's worth, is the authorities caution against an over-analytical approach to goodwill. In view of these authorities, I question the applicability of the approach adopted by the respondents in the capital gains tax manual, which at the time was to divide up goodwill into inherent, adherent.
Yeah, that goes back all toward that dog.
Indeed, my lord. And my submission is the tribunal is right here. One shouldn't be looking to identify different species of goodwill. There is goodwill. It is essentially the value of a business over and above the value of its assets as a general matter, although, as I outlined in opening, you can have negative goodwill in an accountancy sense. But to the extent it's a positive figure, it's a residual figure over and above the value of the assets. And there is not really anything to be gained by trying to break it down and, as Lord Whitnall talks about, just dissecting it up and leaving just a sort of desiccated little bit in the middle. We're better just regarding goodwill as goodwill as an intangible asset. Next point, my lord. My learned friend submitted and sought to rely on the fact that Ms. Rodriguez had accepted that the premium amount was the net present value for the income stream that could be generated from the leasehold interest. And my learned friend took you to some various bits of the cross-examination. The clearest statement to that effect in my submission is at page 286. Page 286, my lord. It's about halfway down. Well, it is your evidence. You have capitalised the 65% and a year's purchase of 2. Yes. Now, in your mind, what does that represent? What is that? So, for the 5-year lease and a reasonable prospect of continuance for the tenant to receive that level of income for that period, he will pay 2, a multiplier of 2 times upfront. Bear in mind, Ms. Rodriguez was saying the YP figure should be 2. My learned friend, so the net present value of that income stream, bearing in mind the risks associated with the income stream, Agreed? Yes. Now, in my submission, that does not in any way undermine HMRC's case. What HMRC is saying is that the premium that would be payable is a market value for the leasehold interests. Now, we know that we're valuing on the profits method, and as I've said, the way you look at that is to effectively see the land as representing a stream of income. Now, to say you are paying the net present value for an income stream is simply to say you are paying the market value for that income stream. So if you had a right to...
Well, I think you say it's inherent in the profits method of valuation. That is, what you are valuing is an income stream, which you then capitalise.
Absolutely, sir. But what is said against me is that the fact that it's a net present value for that income stream in some way is a difficulty for HMRC's case. But in my submission, it's absolutely not. It's simply to restate HMRC's case in terms of net present value. The net present value of an income stream is the market value of that income stream. So if you had a bond that was paying over 10 years a particular rate and you got a net present value, factoring in the risks of that income stream, if you paid, let's say that net present value was 100, to pay 100 for that income stream would be to pay the market value. Malone Friend says, well, why would you do that? Because you're not going to make any profit. The point is that you're doing that on a view that you can exceed by your industry. You will exceed what an REO would do. A businessman, you're taking that approach that it's worth paying the net present value to try and generate profits above. It's also worth factoring in, of course, that the FMOP figure takes into account things like salary that would be paid to the operator. So that's another reason why the fact that it's a net present value for that income stream doesn't in any way undermine HMRC's case.
Yeah.
Next point, my lord. My learned friend took you in the journey through the cross-examination to a particular section. It's at page 305, and this was where it was said that Ms. Rodriguez assumed that the staff went across. And my learned friend, I think, took you to the top of that page, but you're assuming the business is not going across. What am I missing that isn't going across that would? I think they will follow with the land, with the purchase. Why would the staff have got their jobs? You're assuming that all those elements go across and together those elements add up to the lease and the business, don't they? My friend then skipped to the bottom of the page and missed out the middle bit. If I could ask you just to read that middle bit.
Sorry, which page are you on?
So, my lord, 305.
305.
And it starts, what I'm valuing is the lease, what somebody would pay for that property.
Yeah.
Down to, I've assumed yes, I've assumed it's very likely that they will.
I see. So she's saying she hasn't assumed it, she thinks it's likely.
Indeed. So if she had assumed that it did transfer, then there might be something to say, well, she's assuming that the business has transferred. What she's doing...
I think we were at that bit, as it happens. I've certainly marked it up.
Oh, I apologise, I may have missed it.
Maybe I marked it up while I'm not listening to the opponent.
But my submission in any event is that an assumption that something is likely, almost, by definition, is showing that she's not assuming the business is transferring. If the business is transferring, all those contracts would presumably transfer. So again, it comes back to what an REO would assume based, taking into account information that's available on the...
Well, it's not what the RAO would assume, it's what the RAO would perceive.
Would perceive, indeed. Yes, madam.
Predict.
Indeed. Would model it in a way of arriving at a profit figure. Couple of points about personal goodwill. My learned friend's submission, as I understood it, was that personal goodwill is something that's limited specifically to the proprietor, the person running the business. In my submission, that is not correct. If we look at, if we go back to the definition of personal goodwill, it's at 209. And it simply says, it's paragraph 2.9 as well. This is the value of profit generated over and above market expectations that will be extinguished upon the sale of the trade-related property, together with financial factors related specifically to the current operation of the business, such as taxation, depreciation policy, borrowing costs, and the capital invested in the business. So it is anything that is going to generate profits over and above what an REO would generate. So in my submission, yes, it could be the celebrity chef example, where it's the person, Gordon Ramsay, whoever it might be. It could equally be brands, it could be IP, it could be any number of different things. The point is that it doesn't transfer necessarily with the land. It's not inherent to the land in the way that trading potential is.
So that's the distinguishing factor of something that's personal goodwill. It doesn't necessarily transfer with the land. It's not inherent in the land in the way, as we've seen from the definition of trading potential, all the factors relevant to that are things that are inherent in the land. Now my Lord, Lord Justice Snowden asked the wording of extinguished on sale is, I agree, not the clearest drafting. There is a bit more of a clue as to what is meant by that if we go back to GN1. Now, I'm conscious that I'm saying you shouldn't really have regard to GN1 at all. I'm going to look at it for this purpose because it does explain what is meant in that context. It is page 202. Now, just going back for a moment to page 201, it has there the definition of personal goodwill, which is very similar. In fact, I haven't checked, but I think it's pretty much word for word identical. If you look over the page then, 2.5.2, personal goodwill where it can be identified remains with the operator and in principle may be transferred to another property. The comment that the personal goodwill would be extinguished refers to that element of the personal goodwill to be excluded from the consideration of the maintainable level of trade of the subject property, and not the personal goodwill itself, which is an intangible asset. So as I take it, what it's saying, it comes back to what hopefully I submitted earlier, which is that it's extinguished as far as the land is concerned. If you're transferring the land, it doesn't go with the land. And in a sense, that's why you're excluding it from the valuation of the land. My Lord, my next point was just to take you to the definition of operational entity, but I think we've already dealt with that. It's paragraph 2.8 of VPGA 4, and we've seen that doesn't include staff, doesn't include supply contracts, and it doesn't include the tenants, the clients either. It's essentially the land and the trading inventory. And you'll see from the transcript that Ms. Rodriguez did talk about, there's also a marriage value where you have both the trading inventory and the land, but the way that the experts dealt with that was to ascribe a particular value to the trading inventory and then to deduct it from the figure that they'd arrived at. Now, my learned friend also suggested, well, it can't be right, can it, that a business, that because land is particularly well adapted to running a particular business, that all of a sudden there's no goodwill. Well, in my submission, it follows from adopting the profits method for valuing the land that you're looking at the profits that will be generated from that land. And if it's particularly well situated, if it has particularly affluent market, if it's in Bond Street, for example, or whatever it might be, those are factors that go to show what the value of that land is. Now, it is not right, as my learned friend suggested, to say that HMRC's case is that there cannot be goodwill in a business run from a trade-related property. Plainly, there can, but it would only be in the case where the actual operator is operating at a level above and more profitably than an REO would. In those circumstances, you would say, well, this business that is operating on the ground is running more successfully than the benchmark, and the value attributable to that which is above the benchmark is goodwill, personal goodwill. But that's plainly possible. So one could envisage a scenario where one had a very highly regarded chain of care homes and the brand name associated with the care home was sufficient to allow them to charge customers, let's say, more than an REO would generate. I'm conscious of the time, my Lord. I'm very nearly finished. Two final points, my Lord. First, my learned friend, in his skeleton argument 86 to 89, said to you, well, the way you value an asset is by reference to the profits you can generate from it. That's simply how you do it. But in my submission, that is right, but it's right in respect of the land. And that's exactly what I've been submitting throughout. In my submission, the error that my learned friend makes is at paragraph 90, where he goes on to say, well, you apply the same approach to goodwill. And in my submission, there he is simply making the same error as the Upper Tribunal, which is to say, looking at this hypothetical business carried on by an REO, there would be this value. I will then ascribe that value to existing goodwill in my actual business. And to put it very simply, my lord, I cannot simply say, I have a business, somebody else, hypothetically, would run it far better than me. The value that's ascribable to that is goodwill in my business. That simply in my submission does not make sense. Final point, my lord, and on a similar basis, my learned friend towards the end of his submissions asserted that a business, things like the agreements with customers, the suppliers, and the staff would necessarily have value. It was asserted that, well, if you transferred a business from one property to another, it necessarily has value. In my submission, that is just bare assertion. One can very easily imagine a scenario where people are underpaying for the services of the care home, supply contracts are too expensive, and the staff are being paid too much. In that scenario, an REO would come in and say, I have absolutely no interest in anything you're doing currently. I want to buy the land, and I will run the business in the way that I would run it. So in that scenario, in my submission, the land would be worth, in fact, more than the land and business combined. Because the additional annoyance and difficulty of having to strip away all those existing deleterious contracts and arrangements would actually be something an REO wanted to avoid. Now, I'm not saying in any particular circumstance this necessarily goes one way or the other. All I'm saying is you cannot simply assert that a business necessarily has value in this context. Well, I'm very conscious of the time. I have no further submissions unless I can assist further.
Thank you very much.
Great.
Thank you both very much for your very interesting arguments. We will reserve our decision. You will get a draft in the usual way. As you know, that is your opportunity to correct our English and grammar, but not our reasoning, or to raise new points. You will also know that the draft judgment comes with an embargo, and as recent decisions in this court have emphasised, the embargo means what it says. When you get the draft judgment, we would hope you would be able to agree an order in the light of the draft, dealing with the appeal. If you can't agree an order, please make short submissions in writing, and we will make the form of order that we consider to be appropriate. Thank you both very much.